The Honourable Member for Laventille East, Morvant.
Thank you very much, Mr. Speaker. Mr. Speaker, I'm here to give a contribution towards the bill, the Anti-Doping in Sport 2013. And this bill gives effect to the UNESCO International Convention Against Doping in Sport, placing local anti-doping efforts within an internationally recognized legal framework and facilitating mutual cooperation and assistance among signatory countries. Mr. Speaker, the bill serves to address the scourge of illegal drug use in sports, and the legislation, which I am informed was in drafting stage a while ago, since under the PNM administration, attempts to show that Trinidad and Tobago is serious about its commitment to the World Anti-Doping Agency and the fight against doping in sport. I am aware that all of our world-class and elite athletes are regularly tested by the international organization WADA. Mr. Speaker, a perusal of the bill reveals that the implementation of this process will be costly and must involve proper planning. Might I add, it also reaffirms the importance of the national sports policy, including the establishment of the Sports Commission, as there must be a holistic, integrated and systematic framework in the development of sport, rather than a piecemeal approach. In the national sports policy, one of the objectives is that Trinidad and Tobago should become the preferred destination for international events and a hub for sports in the Caribbean. Mr. Speaker, the Trinidad and Tobago Anti-Doping in Sport Bill 2013 is similar to that of its Bermudan and Jamaican counterparts. And Clause 7.3b includes that a part of the function of the Trinidad and Tobago Anti-Doping Board should be that appropriate procedures should be developed to protect the privacy of athletes. What I'm saying is, this information, section 4213 of the Bermudan legislation, has a clause dealing with protection of the privacy of athletes. So I'm asking the minister that this is one area that he needs to look at. This privacy provision is especially important as there would be, obviously, be confidential information being divulged from the respective bodies under the bill. Clause 8 of the bill speaks about the board of the Trinidad and Tobago Anti-Doping Association, which will be appointed by the president on the advice of the minister. In other words, the minister appoints the board. Clause 8.2 states the type of individuals and necessary qualifications needed to be a member of the board, which is supposed to manage the Trinidad and Tobago Anti-Doping Organization. And Mr. Speaker, some of these persons include a former athlete, a former coach, a former sports administrator who has served for at least 4 years, and I believe that this should be someone who has served for a longer period, a person who has qualifications or experience in marketing or public relations. This deals with the persons who should be included on the board. A sports administrator, 4 years is not long enough. Also, you spoke about the marketing or PR person needed on the board, but there is no time frame. So that means somebody who could just, a new PR person. So there should be a time frame there. And well, also it speaks about a person who has experience dealing with doping or substance abuse prevention matters. That is okay. But I think that particularly when we have, I think there's also need for an HR person. So they must have a time frame, you know, how long that person is a practicing professional in that particular field. Clause 17 speaks about the establishment of a therapeutic use exemption committee, and it states that the Trinidad and Tobago Anti-Doping Organization shall establish a therapeutic use exemption committee comprising 3 medical practitioners with at least 5 years experience. Well, the word establish here, does it mean to appoint? Because it says that the TADO shall establish a therapeutic use exemption committee. So I wanted to know if it meant appoint, because I was not sure, because I saw it in, I believe it was Bermuda or Jamaica's legislation, one had established and one had appointed. Okay, good. Mr. Speaker, this is an important committee because they receive and examine applications from athletes for therapeutic use exemptions. And from time to time, some athletes may need to take certain medications which may be on the list of prohibited medications. For example, some athletes have asthma, and their medication, they may be put on certain types of steroids. So the function of this committee includes the granting, denial, monitoring, and revocation of therapeutic use exemptions. So it is important, therefore, that a committee of this nature be fair, transparent, and independent. Clause 86B states that the appointment of a member of the board may be terminated where that member fails without reasonable excuse to carry out any of his duties in a responsible or timely manner. What does timely mean? Because what is maybe timely to one may not be timely to another. So in the Bermudan legislation, section 65B, they suggested 3 months. So we can decide how long you like that to be. Clause 17.3c states, in furtherance of its function, the members of the Therapeutic Use Exemptions Committee shall act independently of the Trinidad and Tobago Anti-Doping Organization and shall not have any other official responsibility within the Trinidad and Tobago Anti-Doping Organization. I agree with this, Mr. Speaker, but what concerns me is how can they act independently of the same board that appoints them. So if TADO is appointing the Therapeutic Use Exemptions Committee, but here is a clause stating that they must act independently of that said board. Clause 19 speaks of a results management committee, which shall, among other duties, notify an athlete of the results of his test and refer adverse analytical findings to the disciplinary panel. Mr. Speaker, I move to clause 22, which addresses whereabout requirements. And this process is indeed intrusive. There are some concerns from some international sporting bodies concerning the whereabout system. Mr. Speaker, the Belgium Sports Union led a legal challenge as they argued that the system violates Article 8 of the European Convention on Human Rights. Both FIFA and UEFA have criticized the system, citing privacy concerns. The Board of Control for Cricket in India also had grave concerns, and permit me to quote the Hindu, a newspaper in India dated August 9, 2009. I quote, "At a meeting held in Mumbai, the BCCI, which is the Board of Control of Cricket in India, has declared the whereabouts clause of WADA as unacceptable for its cricketers." End of quote. Well, Mr. Speaker, this process is indeed necessary, as intrusive as it may appear. The anti-doping process is one of strict liability, and the athlete is responsible to report his or her whereabouts. Clause 5 names all of those to whom this act applies, including athletes, support personnel, national governing bodies, clubs, teams, associations, but gyms or fitness centers is missing from here. Mr. Speaker, I guess this must be an oversight because almost all athletes train in a gym. Why isn't the gym or fitness center included? Is this a safe house for athletes? Many persons involved in sports would have had experience of walking into the bathroom in a gym and seeing persons either taking or injecting themselves with drugs. Most doping takes place in gyms by doctors or by pharmacies. The provision of these substances can be a lucrative business. We cannot, however, leave out the gym in this clause, which speaks about clubs and organizations, which this act applies to. Clause 7.2 speaks about the functions of TADO with regards to planning, implementing, and directing a national anti-doping program aimed at informing and educating athletes on anti-doping matters. I quote section 72A1, which states that part of the education process must include the health consequences of doping, including the use of anabolic steroids in fitness centers. So therefore, fitness centers is mentioned here. It certainly must have been an oversight. It is not mentioned that this act applies to fitness centers also. The minister may need to include this in clause 5E. In clause 26, persons committing anti-doping violations are subject to sanctions. Mr. Speaker, I observe that the only penalty for sporting organizations is the withdrawal of funding, and it assumes that every national sporting organization is funded by the government. Under the current act, if an organization says, I don't need your money, what happens then? Clearly, the government can do nothing. However, the WADA rules will definitely kick in with regards to any breach of anti-doping rules. And this serves to remind us that the reality is that a government does not control sports. It is the international organizations which do. Mr. Speaker, I note that in Trinidad and Tobago's anti-doping legislation, the role of the minister is silent. And I would like the minister to hear me, please. I note in this legislation, the role of the minister is silent, except with regards to the appointment of the board and various committees. In the Jamaica and Bermuda Anti-Doping Act, which Trinidad and Tobago has patterned its own after, there are specific clauses with regards to what kind of direction the minister can give to the board and what he can advise on. And it is missing from ours. Mr. Speaker, permit me to quote the relevant sections in the Jamaican legislation, which in section 7.1 states that, and I quote, the minister may, after consultation with the chairman of the commission, give to the commission directions in writing of a general character as to the policy to be followed by the commission in the performance of its functions, as appear to the minister to be necessary in the public interest, and the commission shall give effect thereto. Section 7.2 states that directions given under subsection 1 shall not relate to a particular athlete, support personnel, or doping control. Section 7.3 says the commission shall comply with any direction given under subsection 1. So therefore, both in the Jamaican and Bermudan legislation states that the minister shall not give any direction or any particular advice when it pertains to an athlete, support personnel, or doping control.
Thank you for giving way. This minister, having extensive experience in sport and elite performance, deliberately took the minister's office, whoever it may be, totally out of it. So once TADO is placed there, the minister cannot influence in any form or fashion anything. TADO is beholden to themselves and totally independent, similar to, for example, the Integrity Commission. So the minister has nothing to do there, and we did that on purpose.
Well, it must be seen to be so, because what you will need to do, that information is not in this legislation. So therefore, there must be a clause stated that about the minister. Okay? The Bermuda Act. All right, well, I already stated what these acts, I wouldn't go into the Bermuda Act, which says the same thing that I was just talking about. And I suggest that it be included in the Trinidad and Tobago legislation, because the bill places no explicit restraints on the power of the minister with respect to the board, and in the absence of such restraints, there is a loophole here for the minister to influence TADO. There is no provision in this bill for retired athletes. I would like to suggest that there be an insertion in this legislation with regards to retired athletes, because I observed in the Bermuda legislation, section 27.1, which stipulates that an athlete who is retired shall give written notice to TADO, or to the Bermuda equivalent, and its national sporting organization, that he has retired. And it goes on to say in section 27.2 of the Bermuda legislation that the retired athlete is not subject to the requirements under the Act, and that where a retired athlete makes a decision to return to competition, he shall then give written notice. And you know, this is to safeguard the fact that someone to avoid testing can then retire themselves. But you cannot just retire, you're supposed to go through the process. Okay, the person could just say, well, I retire so that I don't need to take the test. So therefore, there is a process. So therefore, the person should inform TADO and inform their association that they retire. And if they decide that they will be coming back in the sporting arena, you write and say that. In the definition of sample, I would just like to suggest that urine be inserted because it speaks about blood, and it might not be clear to all that urine is included under biological material. The layman would not pick up that, of course. If you're just reading the legislation, you would think that it's just blood samples, but urine samples be included. Clause 15, reports. Reports should also be sent annually to WADA in accordance with the code, and this is not stated. And this is mandatory, but it is not stated in this section. Section 19 should be amended to say cooperate with the police. All right? I think this has to do with the Therapeutic Exemption Committee, where clause 19 speaks about if they find substance in someone tested, they should report to the police. I would like to suggest cooperate with the police, because the finding of a substance in a bodily specimen is different to possession or trafficking. And if this substance could have been taken weeks before in some cases, for example, marijuana can stay in a person's system for about 30 days. All right, so there is no charge there basically, but yet I think it should be open where in the event that there's any police matter, they be willing to cooperate with the police. With regards to confidentiality, in addition to all that is written in the clauses, everyone should be made to sign a confidentiality agreement formally. A comparison of penalties for the disclosure of confidential information I'd like to give is as follows. In Australia, for the disclosure of confidential information is 2 years imprisonment. In Jamaica, 1 million, equivalent of US $10,000. In Bermuda, 10,000 US or 6 months or both. In Trinidad and Tobago, 25,000 or US 3,900. So I'm not sure the reason why our penalty for disclosure of confidential information is so low compared to the other jurisdictions, because this is a serious matter here. The Trinidad and Tobago legislation provides adequately for appeals from the Therapeutic Use Exemptions Committee to the World Anti-Doping Agency and then to the Court of Arbitration for Sport, and it also further provides for appeals to the Anti-Doping Appeals Panel from the Anti-Doping Disciplinary Panel. And this is a noteworthy expression of due process. Clause 27 deals with the appointment of a disciplinary panel appointed by the President on the advice of the Minister. And Mr. Speaker, I would have preferred a more independent appointment process with regard to this committee and the appeals panel, referred to at clause 31, which is also appointed in like manner. With regards to the appeals panel, clause 32.1 states that the appeal panel shall comprise 6 members appointed by the President on the advice of the Minister. Just wanted to know why 6 members. What happens if there's a deadlock? Particularly in an appeals panel, the figure should be an odd number. So it should be 5 or 7. But it's not stated here because the 6 outlined, the 6 persons on the appeal panel are outlined, 6 persons. All right? I noted that the composition of the Trinidad and Tobago Anti-Doping Appeal Panel is as follows. A chairman and a vice chairman, both of whom shall be attorney of law, not less than 10 years standing, 2 medical practitioners of not less than 10 years standing and who possess experience in sports medicine, a former sports administrator of not less than 10 years standing, and a former international level athlete or former national level athlete. But permit me to quote the equivalent of Jamaica's legislation and their appeals panel, section 22.1 of that legislation, and I quote, Mr. Speaker, a chairman and vice chairman, being both persons who have served as either a judge of the Court of Appeal or of the Supreme Court, persons who have served in the post of a Director of Public Prosecutions or a senior member of staff of the Office of the DPP, sports administration, a sports administrator for at least 10 years, and sports medicine person for at least 10 years. End of quote. I understand why Jamaica's appeal panel includes retired judges, because when an athlete has to appear before a disciplinary committee or an appeals panel, it is serious business and most likely will do so with legal representation. An athlete's career will depend on the outcome of these deliberations and results. I tend to lean towards the serious, high-end composition of the appeals panel stated in the Jamaican anti-doping legislation. Mr. Speaker, Clause 35(1) relates to conflict of interest. With regards to anyone exercising a function under this Act, the Jamaican Anti-Doping Commission was disbanded for this reason. And permit me to quote from the Gleaner of the Jamaican newspaper, say Gleaner, Saturday, July the 3rd, 2010. The board of the Jamaica Anti-Doping Commission has been dissolved. The 15 members of the 2-year-old board have reportedly received letters terminating their services. Jamaica Olympic Association President Mike Fennell confirmed yesterday that the members of the board were asked to resign yesterday. The minister just said that based on the review that was done by WADA, she would like to restructure the board, and therefore she was asking everyone to resign, and then she would reappoint those that they wanted to reappoint. Members of WADA visited the island in May on the invitation of the Minister of Sport to conduct an audit of the 2-year-old anti-doping body. And during the visit, WADA's Director General David Howman, who led the delegation, raised the issue of conflict of interest, as there were members of the board still affiliated to their sporting association on the board. Well, what I want to note that he also said, Mr. Speaker, I will move down. He said, during his visit, Howman praised JADCO, which is the Jamaican equivalent of our TADO, for the advancements made since its inception, suggesting that the issues of conflict with regards to the makeup of the board did not suggest that anyone was running afoul of the code, but the perception that there could be conflict took precedence. And that's it. I want the Speaker to remember this. The perception that there could be conflict of interest took precedent. So here we see that our clause 35(1) relates to conflict of interest with regards to anyone exercising a function under this Act, and this is extremely important, Mr. Speaker. But Mr. Speaker, as I speak of conflict of interest, I observed in this week's Guardian a series of articles about the Trinidad and Tobago Boxing Board, Mr. Speaker. I spoke in this House about a year ago, actually it was March, about the appointment of Mr. Boxo Potts, a boxing promoter, as an advisor to a national boxing board. And Mr. Speaker, I indicated that it was and continues to be a serious conflict of interest. Mr. Speaker, the advisor was appointed to a board that did not ask for an advisor, and the board knew nothing about the drafting of the contract of this advisor that was thrust upon them. Neither were they privy to the contents of the said contract. A perusal of the board minutes of July the 7th, 2011 will show that the acting chairman of the board inquired about the contract, and the board members had no knowledge of the contract of the special advisor to the boxing board. And I would like to quote from the Boxing Board Act, Section 3, Chapter 2152, Section 3(1) and 2, and it is stated that, and I quote, "No member of the board shall be interested in administration or executive of any promoting body of professional boxing. No member of the board shall be interested in any promoter or receive payment of any kind from such promoter or promoting bodies." So what has been done here to circumvent this law, Mr. Speaker, is to put Boxo Potts as an advisor to the board, when in fact he attends board meetings and makes pertinent contributions as the representative of the minister.
Excuse me, very careful.
I will not go into the newspaper reports of this week, but I am indeed concerned because there are many reports. And I will not go into the newspaper reports. There have been many reports this week. But I am indeed concerned, and the people of Trinidad and Tobago are indeed concerned. And I just want to say again, I want to remind this Honorable House of the words of the then WADA President, stating about the fact that, about perception, the perception that there could be conflict must take precedence, which is very important. The perception that there must be conflict of interest is supposed to take precedence over everything else. And Mr. Speaker, there have been many allegations of unfair treatment meted out to former board members and boxing promoters and so on. I won't go into those details, Mr. Speaker, but I asked the Minister to address these issues surrounding Mr. Boxer Potts and the board, the Trinidad and Tobago boxing boards, because at the end of the day, I'm just saying to address the issues surrounding. That's what I'm asking. Address all the issues surrounding this, because at the end of the day, boxing will suffer and sports on a whole will suffer. Okay? Mr. Speaker, I said all of that to say this, because I have observed that there are many committees on this new TADO board. Many committees, and there's the appointment of a board and the appointment of committees, the board of the Trinidad and Tobago Anti-Doping Organization, the Therapeutic Use Exemption Committee, the Results Management Committee, the Disciplinary Committee, the Appeals Panel, all of which require competent, honest, qualified persons of integrity to fill these important positions. And do we have all these persons available to fill these positions? Especially persons involved in sport medicine, sports lawyers, persons familiar with the anti-doping process rules and regulations. The lives and the futures of many athletes will rest in the hands of these persons of substance. And the wrong persons in these positions can make or break an athlete. For example, Mr. Speaker, I read in yesterday's newspapers about the blood sample of a policeman who bounced down the persons in Sealot, and we're hearing that the blood sample is spoiled, Mr. Speaker, spoiled. Mr. Speaker, I think that, of course, someone must be held responsible for this. This is a serious matter. And of course, we must look at the conduct of the persons who have to enforce the law. At this point in time, it doesn't look good for the police service. And of course, persons' blame is pelted left, right, and center. But it is very sad day that now 3 persons are killed, and now we are being told that the blood sample is spoiled. How much time this has happened, and where is the breathalyzer test? This breathalyzer test was supposed to be taken, and everyone knows in law enforcement that right after you're supposed to take a breathalyzer test right away, not 6 hours later. And if we are going towards now anti-doping and so on, I mean, is what is going to happen? What is going to happen in our society today if a simple blood test, a blood sample from a policeman is spoiled? Then we have to make sure and put the right persons in place to make sure that anything that has to be done to a really high standard. Mr. Speaker, I wish to caution the Minister that the appointments to these various committees and boards and so on must not be made on the basis of family, friends, or political patronage. If this organization is to be successful, we cannot afford to put square pegs in round holes. Minister, the future of sports, at least until 2015, lies in your hands. Select persons who can do the job, because this is a serious piece of legislation. I hope the Minister will consider the recommendations made and concerns expressed this afternoon. But before I close, Mr. Speaker, as we look at the big picture with regards to anti-doping in sport, what about our communities in Laventille? What about the recreation grounds in Laventille, East Morvant? I too would like to see more youths from this community being named elite athlete, and of course they must meet international standards so that they too can be subjected to testing. Mr. Speaker, the Coconut Drive Recreation Savannah in Morvant urgently needs to be refurbished. The East Port of Spain Development Company is presently rebuilding the pavilion, but the grounds are in dire need of upgrading. And I met with some of the users of the ground on Wednesday, and Minister of Sport, through you, Mr. Speaker, they have asked me to ask you to come and visit the grounds. So I will write to you about it, and I will send that information, and I would like you to come and tour the Morvant Coconut Drive Recreation Grounds. And I am telling you because they have asked me to invite you to tour the ground. The Morvant Recreation Ground is also in dire need of refurbishing, and this recreation ground is used by many persons from Morvant and the environs. And it is not a laughing matter here. We are very serious about this. It is sad when Malik Secondary School football team cannot train on their own school grounds and yet have to train on grounds which are unsuitable. Both major grounds in the area are unsuitable. Mr. Speaker? Yes, because and the ground is bad in Malik because of the a river that runs within the vicinity. So actually the problem is the river, which is undermining the grounds.
In reference to that river, the Minister of Drainage has been informed about it, and he's going to work with the Ministry of Education, of course, the school and the community to improve the drainage aspect of the river to prevent the sliding of more of the school compound into the river. So we're looking at that.
Thank you very much, Member for Caroni East. Thank you very much. So I await the assistance of the Minister of Sport concerning the Coconut Drive Recreation Ground and the Morvant Recreation Ground. It is well and good to bring this bill to the House to deal with anti-doping in sport, but we must prepare and plan well to bring athletes to international level, and we must therefore start with the community. Not selected communities, but all communities, especially where there are at-risk youth. Proper training facilities must be provided. In order to set up the Trinidad and Tobago Anti-Doping Organization, it is clear that I mentioned before it will be costly, and the Minister must therefore ensure that it is done properly. And I would like to suggest that an expert from WADA be brought in to assist in setting up this whole system. I am aware that the process may be a bit tedious, but the right individuals must be placed in responsible positions to get the job done. Proper facilities should be constructed to ensure that samples can be collected. In the upgrade of facilities, there should be dedicated doping control rooms with separate bathrooms, consultation, processing, and waiting rooms. Doping control stations are restricted areas. There must be competent administrators. Mr. Speaker, a comprehensive education program must form part of the implementation of the anti-doping process, and there is a need to foster anti-doping behavior and create a strong anti-doping culture in Trinidad and Tobago. We cannot overstate the value of sport and the important role it plays in our society. As a former athlete and sport administrator myself, having served on 4 national bodies. And Mr. Speaker, I've never boxed. I have never boxed. I played netball and I played basketball. And there is no video of me anywhere boxing, Mr. Speaker. But there are videos otherwise, Mr. Speaker. So, Mr. Speaker, as a former athlete and sport administrator myself, having served on 4 national sporting bodies, I am aware of the need of this legislation. And I hope that the Minister will pay attention to the recommendations put forward as we strive to move forward in sport through this legislation. I thank you.